Is Ms. Dalton going to be here today?
She said she would try to be able to.
Okay, well, let's recall your case then. She's not here, but I didn't want to keep you waiting, but we can call it later on if she's going to be here.
I wouldn't actually expect her to be at this point. I think we're ready for dismissal was my understanding.
No.
No?
Your deferred prosecution contract is when you complete treatment, you're monitored for 3 additional years. It's in the contract.
Right, I see that. I thought we had amended the order. I do have the statute in front of me that.
I have the
specifies
order you
differently.
entered.
What's that?
I have a copy of the order that you entered with your
Right.
attorney.
Well, I thought that we had a discussion here in court with my attorney, but.
Well.
So I don't know if there's a way. I guess we can wait to see if Ms. Dalton gets online.
Okay. Yeah, there's no record with the court that said there was an early dismissal in your case.
Okay. If there, should I just follow up with Ms. Dalton then if she does not show today?
Yeah. Again, there's nothing in the notes.
I mean, on the order, there's an RCW that's mentioned that I have a copy of it.
I have a copy of the exact agreement. It says basically you're to be monitored 3 years from the conclusion of your treatment. One of the things that we talked to about with Ms. Dalton was that the DV treatment doesn't require a 2-year time frame for treatment. The court agreed with that, said whatever treatment was recommended would be the treatment that you would complete. But it doesn't change the jurisdiction for your deferred prosecution because your deferred prosecution is also monitoring continued lawful behavior. It's not like you can get through the program as quickly as possible, get it dismissed because there's no monitoring then.
I understand. Would it, I'm not trying to be.
Why don't you wait
argumentative.
for your
Would I be
attorney?
able to read
Wait for
the-
your attorney. If
Okay.
she's going to show up, we can do it with Ms. Dalton here. Okay,
Thank you.
Thank you. Okay, Ms. Dalton, looks like you've messaged that you're ready on Mr. Boucher.
Yes, thank you, Your Honor.
Thank you, Mr. Boucher. Come on back up. So where we are with Mr. Boucher, Ms. Dalton, is he has completed his treatment. And I think Mr. Boucher had the expectation that his case was getting dismissed. The court's review of the file and the deferred prosecution program overall found that probation monitoring still continues 3 years after the completion of treatment. That's at least on the form that Mr. Boucher and counsel entered in regards to the deferred prosecution order. Because Mr. Boucher was unsure if you were going to be present today, I did not continue engaging with him because he does have counsel. And it appears that he may have reached out to you to do the hearing or to appear then today.
Yes, I understand the situation, Your Honor. I think there is a significant amount of confusion here. It seems, and I can walk the court through the wax. What I don't understand is number 18, where it says the court will dismiss the charge against me in this case 3 years from the end of the 2-year treatment program and following proof to the court. And then through the end of that sentence, the next sentence says, however, which is contrasting, when a deferred prosecution is ordered for a petition brought under RCW 10.05.020 sub 1 involving domestic violence behavior problem, and the court has received proof that I have successfully completed the domestic violence treatment plan, the court shall dismiss the charges pending against me. And this is under RCW 10.05.120 sub 3. This is actually the statutory language. If we go to RCW, I'm sorry, this is the one that I didn't copy, 10.05.120, the dismissal of charges, sub 3 says exactly that when a deferred prosecution is ordered for a petition brought under 10050201 involving a domestic violence behavior problem, and the court has received proof that the petitioner has successfully completed the domestic violence treatment plan, the court shall dismiss the charges pending against the petitioner. So it's not discretionary, it's mandatory that that dismissal be brought. And this statute currently is effective until January 1st, 2026. We are within the scope of this current statutory language. So what I would indicate in accordance with my research, Your Honor, is that under 1005-155, which outlines the requirements for a deferred prosecution program for domestic violence behavior, the requirements are completing a risk assessment, participating in the level of treatment recommended by the program as outlined in the current treatment plan, and compliance with the contract for treatment. There are no specifications under the RCW about the length of time in the case of a domestic violence program. And what it appears to me is that there are a bunch of WACs that are rather convoluted, but when I was able to get through the code and find the DSHS has a pretty handy form which describes the Washington State Domestic Violence Intervention Criteria, Treatment Services Placement Criteria. There's a full list of placement criteria in WAC 388-60B-0410, and then the requirements are in -0405. And completion requirements are in 0430, but the DSHS has published this kind of guide that tells us they assign a risk level. And so someone can be diagnosed at level 1, level 2, level 3, or level 4. In this case, when we go to the diagnostic, the DVIT assessment that was filed with the court along with his petition, and that was dated 1/29 of 2024, they indicated that they indicated their rationale, and the recommended level of treatment there was level 2, and it was a minimum of 36 weeks of DVIT with a demonstration of full personal accountability. So when we go to the DSHS summary of those levels, this concurs, or this is exactly what I believe the level 2 that's indicated by the DSHS is an assessment indicating an overall medium risk, and there's a pattern, and then it requires the completion of all conditions of treatment, including the goals or objectives on their treatment plan for a minimum of 9 months. So under Your Honor, the governing RCW in this case, the RCW 1005-120, the court does not have the discretion to extend the period of the deferred prosecution brought as a domestic violence behavior problem. Now there may be co-occurring issues, but that does not reclassify the deferred prosecution into a different category, and that is dealt with in the WAC in terms of how the therapists are supposed to deal with the co-occurring issues, and it's basically just having them do whatever they deem appropriate, and that's under WAC 388-60B-0350. It says that the co-occurring therapies must not be substituted for the required domestic violence intervention treatment sessions. And it does mention any substance abuse issues if they exist. And a certified agency, Your Honor, under the
Okay, Ms. Dalton.
statutes
Ms.
has
Dalton,
the authority
Ms.
to make a
Dalton.
decision.
Ms. Dalton, okay.
Yes.
Ms. Carmy, city's position?
Well, I think there is a discrepancy between the RCWs and our deferred prosecution order. Although I don't think that I know this was not the intent of the parties to have a deferred prosecution that lasted for so few months. I do think it's what the statute contemplates. And it'll be something I guess we'll look at for our forms, and my office will need to make it more clear that we do expect at least 2 years probation. I think this was a little bit of an end run around deferred prosecution meetings. So, but the RCW does trump our forms, and I'm not gonna stand in the way of dismissal, but, I don't think that was the intention of the parties.
And I would have
All right,
to
hold on,
disagree
hold
on
on,
that. It
hold on.
was
You're-
our
you're-
understanding.
Ms.
No,
Dalton,
it's
we're-
Clark
we're-
County, she used Clark County's form, it's not ours. So. Yeah. So
Yeah.
anyway,
All right, so do you have an order, Ms. Carmi?
I can prepare an order right now.
Thanks, Mr. Boucher.
Thank you.
And if I may, thank you, Your Honor, but just, and thank you, Ms. Carmi. I do believe that this is a statutory requirement, and I don't see that.
Ms. Dalton, we're done with the hearing.
Yeah.
You've gotten your dismissal. We're gonna give that document to Mr. Boucher.
It would be nice to understand for future reference what the situation will be, because it does seem statutory, Your Honor. That's all I was trying to clarify.
I think you can discuss that with Ms. Carmi in terms of your future dealings in this court, Ms. Dalton.
Is he City of Richfield or that or not? I don't have it up anymore.
Stephen Theophilus. All right.
Thank you, Your Honor. I'll have my client collect a copy of the order.
So I'm gonna go through the folks for the probation hearings at 1:30 just one more time. Christine Berry in the courtroom.
Battleground, yep.